Greetings, everyone. This is Richard Solomon, and welcome to Taking Care of Business. My guest this week is an attorney that I have the greatest respect for and look to as an advisor. His name is David Castagna, and he's up in Rockland County. So, David, welcome to the show.
Thank you very much. My pleasure.
And let's talk about the intersection between criminal law and how it affects everyday people, especially the small business owner, as one of our major topics. By way of background, you have a criminal law practice?
Yes, criminal law practice in New City, New York.
And what kind of cases do you see?
The majority of cases I see, particularly in suburban counties, a lot of drug offenses, unfortunately, a lot of theft offenses, and often burglaries are very commonplace in what we call bedroom communities. Although these kinds of crimes occur everywhere, burglaries seem to be more prevalent in suburban type of settings.
And what other kinds of cases do you handle? Do you handle drunk driving offenses, vehicle offenses? One of
my particular specialties, to the extent that word can be used, is DWI defense, and that is a very common charge. It happens, unfortunately, far too often, but the penalties can be very severe, and because it affects your driver's license, your driving license, insurance, it has a great effect on your life, your business, your livelihood, your family. So it's a very dangerous charge to have, because it carries with it so many penalties and stigma.
Now, I guess in no particular, let's talk just a tiny bit about DWI.
Sure.
If people are pulled over and they are concerned about DWI as being a potential reason why they were pulled over, is there anything that you recommend, and what should they do?
Well, there's several different sections of the DWI law in New York State. There is what we call a section involving a chemical test and a section involving a refusal. So in New York State, by virtue of having a license and a privilege to drive, you impliedly consent to taking a chemical test upon being requested to do so under the right circumstances. So if you're requested to take a chemical breath test or any other sort of chemical test, could be a blood test, a urine test, you impliedly consent to that. However, you have the option to decline, to refuse, and if you do refuse in New York State, and that refusal is determined to be that you refused under circumstances that where the police acted properly, then your license will be revoked administratively for an entire year. So there is a disincentive to refuse. However, if you agree to take a chemical test, then of course, from a defense point of view, you are voluntarily turning over evidence to the police and the prosecution. So, when you're pulled over, generally it's going to be for a traffic infraction or an equipment violation on your car. For example, a headlight is out, a brake light is out, and the police officer suspects that you're under the influence, and there's different indicia of reasons why. They can smell alcohol, the way you're appearing physically, slurring your speech, bloodshot eyes. There's indications of intoxication. They're going to have the cause. People understand it as probable cause. However, I don't think you'll ever see that term in our penal law. The proper term is a reasonable cause. They'll have reasonable cause to believe that you may be driving under the influence of alcohol or a drug, and they'll ask you to step out of the vehicle, and they'll conduct what we call field sobriety tests. And people, generally know what these are, the alphabet, the walk and turn, one leg, stand on one leg, things like that. And then they'll probably ask you to take what we call an alcohol screening exam, or what they call an Alka-Sensor exam, which is a brief preliminary breath test. And if all those factors are indicating positive, they're going to place you under arrest and take you back to the police station, where they will request that you take a breathalyzer, most likely a breathalyzer test, where you blow into a breathalyzer machine. Now, if you do that, there are certain levels of blood alcohol reading which determines what the charge will be. However, if you refuse to take the test, then you will automatically face a suspension of your license, and you will have to appear before an administrative court judge who works for the Department of Motor Vehicles within 15 days to determine whether or not the police acted properly. And if they did, your license will be revoked for 1 year, notwithstanding what happens in the criminal case. So, theoretically, you can refuse an alcohol test, have your license revoked for a year, and be acquitted on a DWI, but your license is going to remain revoked for 1 year because it's an administrative violation for refusing to take the test. In New York State, it's a very ironic twist of law in that you cannot get a conditional license for a DWI or a DWAI unless you actually plead guilty or are found guilty of the charge. Otherwise, if you're found not guilty and you have a refusal, your license will remain revoked for 1 year.
Wow.
And the penalties are tremendous. For example, a DWI is an unclassified misdemeanor, so it's a crime, so you have a criminal record. You'll have to pay a fine between $500 and $1,000. You have to pay a court surcharge of approximately $400.
Wow.
You have to pay a driver responsibility fee to DMV, $250 a year for 3 years. You have to pay to enter the drinking and driving program, which permits you to get a conditional license. That's a $75, I think, registration fee. And then you have to pay to have your license unrevoked or unsuspended. So you're talking, and then you have to pay to have an interlock device in your car, which is, as we all know, it's a device which prohibits you from driving if you're under the influence, because it requires that you blow into the machine to start the car, and requires that you continue to blow in the machine at certain intervals while you're driving.
Wow. Now, so great information. So let me ask you a couple of questions, because I had a whole bunch of questions that kind of hit me.
Sure.
Question number one is, if you're the motorist, can you refuse invasive tests as opposed to non-invasive tests? For example, you were talking about sort of these field tests where you can that you provide sort of either a breath or say urinary output. But what about, blood? The only way I know that they could take blood is they have to stick you with something. Can you refuse saying, look, I don't want you taking blood from me or something like that because it's invasive?
Yeah. The police officers can request, when there's an accident and someone is injured, particularly seriously injured, they usually require a blood test. If you refuse a blood test, then you refused. If you tell the police, listen, I'll take a breath test, not a blood test, I would think the police are going to go with that. But, they can get a court order to compel you to take a blood test, and that can be done over the phone with a judge. So, any of these chemical tests are authorized by the statutes covering DWIs, and an officer can ask you to take any one of those. I've known people who have been asked to take a breath test, and they tell the police, I want a blood test. And the police can accommodate them if they want to. Blood test is the most accurate test. I don't think anything else is more accurate than a blood test. And that's why when they have serious accidents, they compel a blood test, because it's the most accurate test, and really beyond contestation. Like a breathalyzer exam can be attacked, in a number of ways, but a blood test is more difficult.
Now, who actually takes the blood? Is it I assume it's a medically licensed professional in a medical setting. I can't imagine they just send like the fire department or with a paramedic just to grab it. I mean, there's got to be some kind of chain of custody.
It's prescribed by law. The police take you to a hospital. It's prescribed by law. I think it's a registered nurse is authorized. A medical doctor is authorized. A phlebotomist, I think, is authorized. It's specified in the statute. if you look in the vehicle and traffic law, section 1192 going forward, it's probably under 1194 or in that 1193, 1194 of the vehicle and traffic law. That specifies the persons who are authorized to take the test, take the blood.
Now, speaking of taking, can they take your vehicle? Can they?
Well, that's another thing that's going on. Forfeitures. The district attorney's office, particularly where my office is in Rockland County, they're very aggressive. I suspect everywhere, but they're very aggressive in moving for forfeitures, either as part of a plea disposition or just as a separate legal action. And they can seize a car. It's under the health law. It's either under the health law, they have an option there, and under the criminal procedural law. But they can forfeit a car. They can seize a car if it's an instrumentality of a crime. So driving while intoxicated, the car is an instrumentality of the crime, and many district attorneys' offices are aggressive in trying to forfeit these cars, and the money that they obtain from that is used for law enforcement purposes. So there's an incentive for them to do this because the money goes, I think, directly back to local police departments and or the district attorney's office. See,
that's a little bit of a problem because the people who are prosecuting benefit from the seizure, where I think it'd probably be a little, this is just an opinion here, but wouldn't it be a little bit more neutral if they did not directly benefit or indirectly benefit? It looks like there'd be less of an incentive. I'll give you one quick story. On my end, I for people out there who are listening, this is Taking Care of Business. I'm Richard Solomon, and I'm an attorney. And one time I was representing a limousine company, and apparently the driver on his own took his limousine unauthorized and was, I guess, going out in sort of the eastern end of Long Island during the summer. And I think at 4 o'clock in the morning, he got pulled over for going the wrong way on the highway and all this other stuff, and the vehicle was seized. Now, I went over to, I guess it was Central Islip, to get the vehicle back, saying, look, this was not on company time, this was not authorized, and we fired the guy. And basically they released the limo back to us. It was a $75,000 limo, and that also brings into the question of sort of equal protection. If I'm driving, let's say I'm driving what was that car? The Yugo. They don't make them anymore. So I'm driving the Yugo. And that's seized, as opposed to the highest end sports performance car, I guess like a Lamborghini or something like that. Isn't there sort of a disproportionate punishment that the seizure of the high end sports car is so much more punitive than the car that's worth $7 for scrap metal?
Well, objectively, yes, but subjectively, a person driving a Yugo or what we may classify as a lower-end car, the loss of that car may be just as significant to them as it may be for someone who's wealthy enough to afford, a Bentley or a Rolls Royce. So, I mean, I think it's disproportionate objectively. Yes, the Bentley's worth $200,000 and the Yugo's worth $10,000. But I think to those individuals who lose those vehicles, I think respectively, they feel it the same way. But I think they seize whatever they can seize. I don't think they make a distinction, and I'm not aware of anything in the law that provides for the parameters of what can be seized, the value of what can be seized. I think if they can seize a car, if it doesn't have a lien or a loan on it, or if it's not owned by a third party, which I don't think prevents them from seizing a vehicle and forfeiting it, but I think they're less likely to seize the mom's vehicle when the son was driving it. But in many instances they do, because they blame the owner of the vehicle, whoever it may be, particularly if they're aware that the person who's using the car drinks or drives while drinking, that they really don't care in those situations. But in some situations they'll say, it's my mom's car, and I drive it to school every day, whatever, she loaned it to me, lets me use it, and then the person gets in trouble with the car. They may not, a case can be made not to seize or forfeit the vehicle. If the vehicle has a loan on it, they're less likely, because the loan has to be satisfied. So district attorney's office is not going to seize a vehicle and have to worry about paying off a loan. So, but what they're trying to do these days, I think, is they're trying to make a deal as part of a plea disposition, hey, we'll make you this plea bargain, but as part of the plea bargain, you got to turn over the vehicle. Or what I think Orange County here is doing, I heard, is that they passed a law that allows them to negotiate a money settlement amount. So they may say, hey, listen, we're going to give you a plea bargain, and you know what? You can keep your vehicle, but you got to pay us $1,000. So, or whatever it may be. So I think now that there is a law, I think it's a local law in Orange County, I'm not sure, but I did hear about it, where they can negotiate actually a money settlement for you to keep your vehicle. So, I mean, you know, they're trying to obtain monies, and they're trying to punish people simultaneously with this forfeiture law.
All right, we have to take a quick break. This is Richard Solomon with David Castagna. And when we come back, I'm going to ask David about the role of videos and how that plays in police vehicles. So we'll be right back. Keep it locked in here on Taking Care of Business. Be right back.
What I really need.
All right, welcome back, everybody. This is Richard Solomon, Taking Care of Business. And my very special guest is David Castagna, who I have the utmost respect for. He is a criminal attorney up in the northern counties of past Westchester, for those who may be listening in other parts of the country and other parts of the world. Anyway, what we were talking about is sort of how criminal law affects all of us, especially those in business, and sort of the whole costs. And there are many, many deeper costs to being a criminal defendant, other than the actual, maybe the fine that you end up possibly paying and facing. Actually, I was in the Red Hook Community Justice Center earlier today, as a matter of fact. Mm-hmm. So one question I have was, we see, at least on television, videos taken from police cameras. Do you see that more and more being introduced as evidence by the state or the prosecution in criminal actions?
Well, the use of videotapes, in my experience here in New York, has been with respect to confessions and statements that the police are taking from defendants once they're placed under arrest and brought back to the police station. Videotape, video cameras positioned on police vehicles, I haven't seen that in a very long time. And I think the reason is because it was very damaging in some instances for the police, because it would capture police conduct that at the time the police may have thought was innocuous, but turned out to be helpful to the defense. So I have, in all the cases I've handled in most recent years, I haven't seen any video that has been obtained from cameras mounted on a police car. However, the police departments have stepped up use of video and recording equipment when they're interrogating a defendant. In fact, I believe that the federal government issued a proclamation not too long ago where I think that all interviews, all interrogations must now be videotaped. But again, that has to be confirmed. I'm not sure in what form that came out, that declaration came out, but I understand that that is now the policy of the federal government, and I think it's slowly but surely becoming the policy of the local police departments. And so just be aware if you're called down to the police station, or if you're placed under arrest, you find yourself in an interrogation room, it is likely that they're recording the session. They're recording what's being asked, what's being answered, and you and the officers in the room. So, do you have to be told that you're being recorded? No, and I know some people who've been interrogated. They were surprised to find out they're being recorded. It does not have to be revealed that you're being recorded. That's an important fact. Right. Now, there are times when people call my office, and before I get a chance to say, oh, you need to call David Castagna, I hear some intake information, and I see people call about either tax-related questions or something else, or that the police are calling them and are asking them to visit the police station. And the first thing I always say is, you must call an attorney, have some attorney call up the police and find out what they want before you just march in, because it's never good when the police call you. Could you kind of talk a little bit about that? Because sure. I see all kinds of stuff, especially with
the stepped up enforcement of regulatory and taxation issues?
Well, let me just say this to all your listeners, that whatever show you see on TV or radio show you may hear, or whatever advice that may be given out to the public, that should not be substituted for advice that you would get from an attorney you would retain or consult on a confidential basis. So this show or any of the shows that people may be listening to, whatever broadcast involving legal information or legal discussions, it should not substitute for advice, but that you would get from an attorney you would hire or retain or consult. As far as when the police call, it's my opinion, and this has happened on several occasions. It's my opinion that you do not go to the police department and voluntarily speak with them. And you see a lot of these television shows, whatever it may be, Law and Order or NCIS, whatever these shows are, they annoy me because they're so inaccurate. It's always a given in these shows that there's an attorney in the room with their client and the DA or detective sitting across the table, interrogating them. That doesn't happen in real life. It doesn't. The only way I would ever accompany a client down to the police station is if there was a district attorney there, and if it was some sort of proffer, or what we call queen for a day, or some sort of cooperation agreement that they're offering my client. I'm not going to go down so my client can have a discussion with the police so they can obtain information and improve a case that's probably weak to begin with, because an officer, called me once and said, "Hey, can we speak to your client? We have our case, but we just want to talk to him. It's not a big deal." And I said, "Listen, if you have your case, you don't need to speak to him. He's not coming down." You got to understand that I would venture to say at least half of the criminal prosecutions would never exist but for statements made by a defendant. And even if you say you were there but didn't do it, just by saying you're there is enough for them to charge you, because that connects you to a crime scene. Even if you protest that you didn't do anything, the fact that you're putting yourself there is enough. So what you think may be innocuous, what you think that maybe you're defending yourself or providing some sort of explanation, what you're really doing is digging yourself a hole. And, a lawyer who says to you, "Yeah, I'll go down with you to the police station, we'll see what the police want to talk about," that may not be the best advice unless, again, a DA has called your attorney and told him or her that we're going to work something out for your client. We want him or her to cooperate with us against unknown assailants or co-defendants or other people they believe may have criminal liability, and we're gonna help your client out. That's something you want to explore. But my advice is, if an officer, a detective calls you and says, "Come on down, we want to talk to you," the first thing you should do is call an attorney.
Oh yeah. Now, just to take two themes of what you just talked about.
Right.
The first is the accuracy of television and movies.
Right.
When I watch any of these legal shows, and I don't really watch a lot,
right.
You'll see something, and you'll see like objection. It'll be like sustained. I go, "You're kidding, right?"
Right.
And my wife always kind of says like, "It's just TV," and I'm like, "No, that would never happen." And so that's the other thing is when you talked about statements. I don't really do any criminal law at all, but the one thing I do a lot of in the criminal law is sort of the truck regulation summonses. And what you'll see is on almost every truck summons ticket, there's a little box on the ticket where it says, remarks or statements, whether it's either on the face of the ticket or on the back on the notes. And it'll always be like, "I didn't know I was off the truck route. I only left my truck for a minute."
Right.
There's always something. And it's always just that little gotcha statement, because the driver necessarily wasn't thinking about the consequence. They were trying to explain what was going on. And a little do they know when they say, "Well, I didn't see the sign. I didn't know that I was off the truck route." And I always see these things and I'm like, if they just didn't say anything, I'd have a better discussion platform, because you're already starting with a ticket with sort of almost a confession, already built in.
That's right. Well, it's the statements that really, the best evidence, other than a videotape of an offense, the best evidence, I mean, from a prosecutor's point of view, because I was a prosecutor for 5 years, the best evidence from a prosecutor's point of view, other than a video, of a real-time video of the happening of the event, is a statement, is a confession, is an admission, because a jury says, why would someone confess to a crime they didn't do? And, there are confessions that can be false, that can be coerced, and there are ways to attack that. The law provides for legal process to test statements and to test whether or not the person was handled properly by the police, whether they were instructed on their rights. We commonly call Miranda rights, and whether a person was coerced and whether a person was could have been under the influence of drugs or alcohol or other things that could cause them to be incapacitated or under duress. So there are ways to attack a confession or an admission, but very often these things are admitted into evidence, and very often they're very damning for a defendant.
Hi, this is Richard Solomon. My guest is David Castagna. He's an attorney in New York State, in New City, Rockland County. His phone number is 845-638-2889. I truly, he's one of the people that I seek advice from. And I've been doing this for a long time, so it just shows you how much respect and admiration I have for David. In terms of some other topics now, just switching over to sort of small business people and just the consequences of people getting caught in the crossfire of criminal prosecutions of one kind or another. And it's amazing how many there can be. What do you see that affects sort of regular folks? Well,
first, from a victim's point of view, businesses, retail businesses, banks are often targets of theft and forgeries, fraud. They just had in Rockland County, they just arrested, I think, 36 people. And the alleged scheme was that they would open bank accounts and they would deposit altered or modified postal money orders or other money orders into the account, and they would withdraw the money before the bank realized that the instruments were forged or altered. So in that instance, the banks are victims, and similarly, retail establishments, malls. We have the second largest mall in America in Rockland County. I believe it's the second largest or third largest, and there's hundreds of cases a year coming out of that mall alone of theft, employee theft, regular customer retail theft. And so from a business point of view, crime is expensive. And so your listeners who own retail, even the smaller stores, strip store malls, places like that, they're targets as well. So your listeners who may be in those businesses, who may be employed by those businesses, whose jobs are affected, by theft. People, businesses close down. I mean, theft takes a great toll financially on a lot of businesses. So, businesses can be victims. On the other side of the coin, you have businesses that are prosecuted, and home improvement, for example, which is very big in the suburbs. Don't forget, New York State, we have 62 counties, okay, and many of the counties are suburban, and many of the counties have a lot of different home improvement businesses, from paving to roofs to bathroom installations to landscaping. And, now these businesses have to be properly licensed. For example, in Rockland County, you have to have a home improvement license issued by the county, which requires that you have a certain amount of insurance, disability insurance, liability insurance, and there's money involved, there's a fee, what have you. But if you don't have this license, you can be prosecuted for a misdemeanor for a crime, and that happens quite often. For example, if you're in the construction business, another facet of the law that they use against businesses, if you're, for example, in the construction business and someone gives you money for a home improvement project, let's say a kitchen, that money is almost treated like a trust under the lien law in New York State and the general business law. If you don't retain that money and use that specific money towards that project, for example, if you use that money for another project or for personal use without actually starting the job, you can be charged with a grand larceny. So, for example, if a business has a bank account and they have 6 or 7 clients and each client is given them X amount of money for various jobs, okay, if a client demands an accounting of the money they gave to that home improvement person, that person has 30 days to account where the money is, what goods and supplies have been purchased, and what has been done towards that project. If they can't account for that money, they can be charged with grand larceny. And in Rockland County, I've seen it. I've seen home improvement people, construction people charged with grand larceny. Basically, it's misappropriation of funds. When you take money, it was almost like an attorney escrow account. You take money from people, or there's money in your account for fees or for closing monies or deposit monies. You can't use that money for any other purpose. You have to use it for the purpose that it was given to you. Same thing if you're, if you're building a bathroom and someone gives you money for the bathroom, and they expect you to buy, supplies, and they expect you to spend money on labor. If they send you a letter saying, listen, it's called a 31-day, we call it a 31-day letter. If they send you this letter and you can't account for the money, or you haven't kept records of where the monies are or where they went, the district attorney can turn around and charge you with a crime, with a felony. So, those are just 2 examples. A home improvement business, which affects a lot of businesses in this state. Just beware that you have to be licensed. You have to check the county where you practice to see what the licensing requirements are, and you have to have very good accounting practices, and you have to be solvent. You can't be flying by the seat of your pants when you're running a business, and or you can get in a lot of trouble.
Right. Now, what's interesting is talk about the prosecution of unlicensed, construction people. I had a couple of cases in the last few years where people would make a phone call. I had 3 or 4 guys were arrested, and what would happen is somebody from the New York City Department of Buildings would go down to a work site, look at the permit, and then say to the people there, "Who do you work for?" or "Who are you working for?" And either they couldn't prove who they worked for, or they gave the wrong answer. I was working for Acme, and it turned out that the license was pulled by Smith or Jones, or Smith and Jones, whatever. And then they'd be arrested, and some of that could be very nasty. I know that if it was like your first offense, the DA was looking like for $3,500 in terms of fines. And number one, it adds up and it becomes a problem. And one thing we didn't really talk a little bit about, but maybe we should have, and we only have like a minute and a half in this segment, is how do all these criminal problems affect the ability to obtain insurance? Like, if you have a DWI arrest, can you actually become an insured driver? And if you're a business and you've had sort of criminal convictions and this and that, what does that do for your ability to get insurance and bonding?
Well, I think with DWIs, it's certainly going to affect your insurance, and you'll probably be placed in a high risk group, which is going to cost you a lot of money. I think there are insurance companies, or even maybe government, quasi-government agencies that will insure you, perhaps, but you'll be in a high assigned, what they call an assigned risk, and it'll probably be very expensive if you can get insurance at all. But you got to understand too, we're talking about fines and money. There are jail sentences. There is incarceration that's authorized by any level of misdemeanor offense from a DWI and up. So even for violations, for disorderly conduct, for harassment, you can go to jail. So in addition to fines and surcharges and other administrative costs, you can find yourself going to jail. We're talking about the impact on people. the impact on people's lives, on people's businesses, people's livelihood, I mean, is tremendous. You know, if you have a commercial driver's license, you mentioned you represent truckers. If you have a commercial driver's license, you get a DWI, forget about it. You're not going to see that CDL for a long time.
Yes.
And now in New York State, they've passed administrative law with Governor Cuomo's office was behind this. They have a lifetime look back. If you have a certain number of DWI, or what they call serious driving offenses, or SDOs, you can lose your license for your entire life. You can lose your license for 5 years, for a lifetime, depending on what your history. And they're going to go back. It's retroactive.
Yeah.
So, you know, you got to be very careful before pleading guilty to a DWI or reckless driving or a seatbelt law, which is 5 points. You got to be very careful today.
Let's hold it right there. This is Richard Solomon. We're rocking through this incredible hour of radio on criminal law. We'll be right back.
What I really need.
Welcome back. This is Richard Solomon, Taking Care of Business. My guest is David Castagna. He's an attorney in New York State. His phone number is 845-638-2889. And we've had so far just an incredible 2 sections of this hour talking about a lot of different topics. But we're going to move into a new set of issues. Let's talk about sealing of records, expungement of records, because I'm sure that's really important to people who don't necessarily want with all this digital information out there, to the extent that you can have your criminal records sealed from the public, I guess that would be a good idea.
Yeah, well, you know, one of the other collateral effects of being convicted of a crime is now you have a criminal record, which in New York State, unfortunately, we don't have here a true expungement statute. Okay, we've had various ways to try to ameliorate the conviction, or for people of certain ages, ways to seal a conviction. For example, if you're 16, 17, or 18 years old, if you have not reached your 19th birthday, you are what we call youthful offender eligible. And if you're convicted in a justice court or a village court, okay, the conviction is sealed. That means the record is sealed from public view. You can honestly say that you have not been convicted of a crime. It's not considered a conviction, okay? And, you know, we have, 62 counties in New York State, and it's organized by counties, cities, towns, villages, and town and village courts are called justice courts, okay? And in those courts, the conviction would be sealed automatically. However, in county court, okay, when you're facing a felony charge, then it's at the discretion of the judge. So the judge can grant youthful offender adjudication or cannot, and that's very important. So that's one of the ways that you can have a conviction actually sealed and not have a record. The other way one of the other ways that you can avoid having a criminal conviction is if, of course, the case is dismissed, or if you're acquitted, or if the matter is what we call adjourned in contemplation of dismissal. The acronym is ACD, which means that the charge would be dismissed after a period of time, and the person would be placed in the position they were in prior to the arrest. So that is another way, again, to avoid a conviction or ameliorate the fact that you've been charged with a crime. So New York State does not have a pure expungement statute. They have sealing statutes, and in fact, very recently, they passed a set of laws involving drug offenses. And, you know, in New York State, particularly in Rockland County, and I know in Westchester County, Orange County, many of the counties in New York State, they have alternative disposition programs or alternative courts. We call drug court, for example, where a person with a drug-related, alcohol-related offense can go to drug court, obtain treatment, and in most instances, where they face a felony, the felony would be reduced to a misdemeanor. So in those instances, you can avoid a felony conviction and then face perhaps a misdemeanor conviction. But with the new set of laws that they passed, if you do enter a drug court or a state-sanctioned drug treatment program, that charge ultimately, if it's reduced to a misdemeanor, ultimately can be sealed. Okay, they can seal a drug-related charge, and in fact, I think the court's permitted to seal up to three prior misdemeanor drug-related charges. So again, New York State does not have a true, and these sealing orders, the sealing of these charges can be opened up under certain circumstances. So again, it's not a true expungement in New York State. The other avenue you have is to ask the court for what we call a certificate of relief from civil disabilities, and I'm sure you heard of that one, Rich, right?
Actually, I've heard of it, but I'm not exactly sure what it is. So,
well, a certificate of relief from civil disabilities is a document that the judge signs that basically says, hey, listen, this guy was convicted or this person was convicted of this crime, but don't hold it against him. You know, I'm giving you this certificate to relieve you from the disability of the onus of the conviction. So there are employers, there are state agencies, where if you applied for a job, even certain licenses, perhaps, real estate license, insurance brokerage license, nursing license, cosmetology, whatever it may be, that the Department of Education, for example, may regulate, that certificate of relief may serve as a way to clear the path so you can obtain a license. And there's also, under the corrections law, there actually is, I believe it's section 750, 52, 753, which actually says that a person should not be denied employment because they have a criminal conviction. And, basically those statutes encourage employers, and I think they actually use that terminology, encourage employers to hire people, even if they have a conviction, unless the person would be a danger to public safety or the conviction relates to the job that they're considering. So, for example, if you're a cashier and you're convicted of stealing from your employer in your position as a cashier, and you apply to be a cashier somewhere else, that employer may have the proper grounds to say, hey, listen, this isn't the right job for you, based on the fact that you've been convicted of petty larceny or whatever it may be in the same position. However, let's say that person was given a position where it doesn't involve money at all. Let's say the person is employed as a landscaper now, and they have a petty larceny conviction, for stealing when they worked for a retail establishment, whatever. They're not going to be handling money, whatever. Then an employer might be, more willing to say, you know what, I think that, this is going to work out. I'm not going to hold your conviction against you. But, basically the law is saying, the certificate of relief from civil disabilities, basically they're saying, listen, don't automatically, deny this person employment because they have a conviction. But you know what? In reality, I hear it all the time. I get calls from people saying, I had a conviction from, X amount of years ago, and I was represented by so-and-so, or I didn't have a lawyer, and now I applied for a specific job, and I can't get it, because they're holding this against me. What can I do? And what you try to do in those situations, you try to obtain a certificate of relief. You try to go back to the judge or back to the court and get that certificate for the person, or you try to see if the conviction was properly obtained, if there's a way to open up to conviction and perhaps get a better disposition for the person. I mean, there are ways to attempt to ameliorate what has happened to that person, and and also the other big trend in New York State is immigration consequences. We have a lot of immigrants in this country, a lot of people who have status or don't have status, and in either case, a criminal conviction, and it could be regardless how nominal the conviction may be, it could very well affect your ability to either remain in the country or to become a citizen. And so where that used to be a collateral consequence meaning that lawyers generally did not make that part of their usual concerns. It is now a direct consequence, a penalty, in fact, the Supreme Court has said, and lawyers must now counsel clients who are not citizens as to the implications of a conviction. And for a short period of time, they actually held this law to be retroactive. So if you represented somebody 5 or 10 years ago, and now they can't become a citizen, or they lost their permanent residency status or whatever, they can come back and complain and say, hey, that lawyer didn't tell me that this would happen to me. But I think that's been reversed now. There is no retroactivity. My understanding is that the Supreme Court, the federal government, and now New York State has declared that is not retroactive any longer, that is the law going forward, but not retroactive any further. But again, I would advise people to consult their own attorney on that subject.
Real fast, on one thing to add to the ceiling expungement issue is when I do some of the truck regulation fines, depending on the circumstance, I will ask that the corporation be substituted for the driver.
Right.
It's not always possible. Certain things are just driver specific. Like if you're off the truck route, it's because the driver was off the truck route. But if it's more like you had an unsecured load or something,
equipment violation of some sort.
Yeah, you'd say, look, will the court entertain a substitution of the corporation as the defendant? Because at least this way, if a corporation takes the hit, pays a fine, at least the criminal record's against a corporation. And if it's big enough of a corporation, it's kind of diluted to some extent, especially if it's like a company with, like, say, dozens and dozens of trucks, big company, lots of drivers, then it may go to the company's insurance, but it does try to help out the driver a little bit. But
sure.
So let me ask you this. If you have that certificate of relief of civil disabilities, does that protect you from cross-examination in a civil action where someone tries to attack your credibility, known as impeachment, by saying, isn't it true that you were convicted of this kind of felony, Mr. Smith? Is that the antidote?
No, the certificate doesn't erase the record. It doesn't erase the existence of the conviction. In fact, in the civil context, witnesses really have no rights when it comes to impeachment. In the criminal arena, a defendant has certain rights as to what the scope of the cross-examination can be regarding prior convictions, prior arrests. But for a witness, just a witness in a criminal trial, or witnesses and parties in a civil context, my understanding is that it's all fair game because bias, veracity, interest, those are never collateral issues. And honestly, a witness has no rights when it comes to a criminal record, and a certificate of relief does not erase or obviate the existence of a conviction. It just tries to ameliorate the effect it may have on employment and obtaining licensing for certain occupations.
Now, what are some of the other consequences that we may not have addressed for some like a felony convictions? Like, do you lose the right to vote? What are the other consequences?
The right to vote. I think convicted felons, they can't serve in jury duty. That's one of the questions I asked you. I think on a jury questionnaire is, have you been convicted of a felony? I mean, I think you're excluded from serving on a jury, and I think you are excluded from voting. Although I never personally investigated that. I never met anybody who said, "Yeah, I'm a convicted felon, I can't vote." So I don't know. I know that the certificate of relief doesn't provide for a person to be eligible to run for public office. So if you have a felony conviction, I think you might be excluded from running for public office. I'm not sure, but I think there are people in government who have prior criminal records. So I'm not sure. It might vary from state to state. It might vary between state and federal government. I'm not sure, but That's an interesting question to investigate. I think the conventional wisdom is that if you're a convicted felon, you can't vote, but I'm not sure what the law on that is.
Well, obviously, if you've pled guilty to certain crimes, that could put your license at issue. I know that if you, certain bar journals, for example, have the disbarment, proceedings published. I know that the New York Law Journal, I think, has that. The DC Bar Journal has that because I read both of those publications, and I definitely have seen, so and so was suspended or removed from practice because of a felony conviction.
Oh, sure.
And so you see that. I'm sure that's true in other trades. I'm sure if you're like a physician and you're convicted of a felony, that probably has something that may impact your license. I can't imagine that it wouldn't.
Not as it would, I think, with an attorney. I think, the surest way to get disbarred or suspended in the state, disbarred, I should say, is if you're convicted of a felony. I think that's it. I think that's the most the fastest path to disbarment is a felony conviction. I mean, even President Nixon, I think, was disbarred. I don't think he responded, in fact, to the disbarment disciplinary proceedings. I think he didn't respond, and he was disbarred. But I think that if you read the Law Journal and there's a section, like you say, that there's always, at least once a week, if not more, there's always someone being censured, suspended, admonished, or disbarred. So it's a lawyer's nightmare to have to face those proceedings, but that's a clear example of an effect of a felony conviction on someone who's licensed, a professional license, absolutely. All
right, and we only have 2 minutes left. In the last 2 minutes, is there any topics we haven't discussed or anything that you're itching to share with everybody?
Well, I just want to say that, the thrust of any legal show on criminal law, criminal defense, if you own a business, particularly if you have a professional license, a commercial driver's license, a license for an occupation, the most important lesson and the most important advice you can get from a show like this or any show similar is that you need to hire an attorney if you're charged with a crime. And you'd be surprised how many people try to come to court and resolve a case without being represented. And it's an unfortunate situation. But there are a lot of options for people. People say, well, lawyers are expensive. Yes, lawyers can be expensive. But, if you can't afford an attorney, there are organizations that offer free legal services. In every county in the state, I'm fairly confident that there is either a public defender's office or a legal aid office or some sort of office that provides free or low-cost legal representation. So the most important piece of advice that you can take away from this show is that you need to consult an attorney if you or someone in your family or a friend or a loved one is charged with a crime. And if someone comes to you and say, what should I do? The first thing you should tell them to do is, let's contact an experienced criminal attorney. And if you don't know an experienced criminal attorney, you can contact the Bar Association in your county. And they have panels of lawyers that specialize in different areas of law. And so that's the most important advice, Rich, that I can give somebody as a criminal defense attorney is to promptly, retain an attorney or obtain legal services, and do not go to court alone.
There you go. All right, Richard Solomon, Taking Care of Business with David Castagna, 845-638-2889. That's for us. That's it for us. We'll see you next week. Thanks for listening. And David, thank you.
No, thank you. My pleasure.
Whoa!